Is this your personal opinion?
Hey, this is something which has happened over the years.
No, it may have happened. Nobody's going to get into that. The question is, were these cases discussed in Parliament? Were they discussed? Did they form the basis of why this law had to come? Because that's what we are hearing this case.
Why we are referring the cases from Tamizuddin Khan case, वहाँ से लेके तमाम ये नुसरत भुट्टो केस और फिर ये रेकोडिक केस और सुप्रीम कोर्ट बार केस और ये फिर अकामा केस जो है और फिर ये हुदैबिया केस सारे लेके आप हमें ये चार्जशीट करना चाह रहे हैं कि सुप्रीम कोर्ट ने इन तमाम को देखने के बाद जो कॉम्पिटेंस नहीं थी उसने लॉ बना दिया और अब हम उसे लेजिटिमेट कर दें. You want to invoke us the doctrine of necessity to legitimate this law?
No, sir. No, sir. To the contrary. I think मैं अगली बात जरा कंप्लीट कर लूं.
Mr. Attorney General, I think हमें थोड़ा सा हौसला रखना चाहिए सुनने के लिए तनकीद. I don't think you use the word charge sheet.
I have not.
You are simply stating a fact, and we should have the patience to hear your submissions. Your submission is, from what you have just commenced by stating, that 184.3 may have done some very good work as well, but 184.3's consequences have also been, I don't want to use the word disastrous, but maybe not so good. So you're just stating that Parliament does not have to mention each and every case, but this is the cumulative understanding. I mean, you don't have to spell out everything. Tamizuddin Khan was not 184.3, etc., but these cases were. So you are just stating a fact, and we should be sort of have the wherewithal to accept it. I mean, we were a council at some stage, and we are judges now, and we are citizens always. So if someone is stating a historical fact to build the argument why 184.3 may have been given a right of appeal, so let us hear him with patience. And if you don't agree with that, by all means write judgments whichever you want to, but at least please continue. I mean, otherwise we'll be forever. I mean, you didn't do this thing. You are saying we did it, and you're just pointing, showing us the mirror. Fine, I have no problem you to show me a mirror about all the judgments I've passed which are wrong. I have absolutely no problem. I would say thank you. I may learn from it, and I won't commit the same error or mistake again. So please proceed.
Mr. Attorney General, the question still remains, which I've already put before you, whether the court did good or whether the court did bad, and beauty may lie in the eye of the beholder, and there may be people who say this was good and that was bad and that was not so good and that was not so bad, and we can carry on ad nauseum. This is not a debating society. We are not sitting here to receive a public lecture from you, sir. You are Attorney General. Kindly tell us what is...
If there was a remedy of appeal.
Sawal sun lein.
If there was a remedy of appeal.
What does that have to do with the...
These consequences could have been averted.
बात तो सुन लेना. What does that have to do with the legislative competence of the...
I have, as I stated, my lord, I have already made submissions to it. I am referring to what yesterday, Justice Hilali...
If there is legislative competence, तो बात खत्म हो गई.
जी.
आप हमें ये दस्तूर दे रहे हैं.
ये इसलिए जरूरी है सर कि ये आपके पास अभी not long ago, record date के ऊपर under 186, you had to come and protect what had happened.
Then the question that my learned colleague has asked you, that becomes relevant. आप हमें बात कीजिए लेजिस्लेटिव कॉम्पिटेंस की. आप हमें कन्विंस कर कीजिए कि आपके मुताबिक, या आप कह दें जी वो सब गलत कह रहे हैं, बात खत्म हो गई. I don't have to do anything. Onus lies on them. You kindly tell us about legislative competence.
कल जस्टिस हिलाली ने एक कमेंट किया था, एक ऑब्जर्वेशन थी उनकी. उन्होंने कहा कि 184.3 जब एक्सरसाइज हुआ.
Mr. Attorney General, I've been a counsel more years than I've been a judge, and I would always prefer that the judges let me complete my submissions. They may not accept my submissions, hear my submissions, and discard my submissions, but certainly your right of making a submission, I think, otherwise we don't need to give you a notice, we can decide the matter ourselves. So please proceed in your own way.
While concluding my
दो चीजें देख लेते हैं जी. ये तो यहाँ तक everyone agrees that there were certain issues regarding 184 which agitated or which disturbed the executive and the parliament. Fine. Point taken. Second point, the law that you enacted, that law, everyone agrees कि ठीक है, law में कोई ऐसी चीज नहीं है. बाज यहाँ होगी, लेकिन वो लॉ, नो वन सेड कि ये लॉ जो है ये किसी तरीके से इन्फ्रिंज कर रहा है आपके फंडामेंटल राइट्स को एज सच डायरेक्टली। असली जो मेन चीज आपने एड्रेस करनी है वो है उस लॉ की, आपकी जो लीगल कॉम्पिटेंस है, उस लेजिस्लेटिव कॉम्पिटेंस। आप प्लीज उस पे आ जाए।
My lord, I'll come to the question that you had raised before the
आप अपने
proceedings.
आर्ग्यूमेंट्स करें।
My lord, I have
my question, take it at the end। पहले अपने आर्ग्यूमेंट्स खत्म करें, like the चीफ जस्टिस जस्ट सेड कि भाई पहले उनको तो बोलने दें, आप जो आप बोलना चाहते हैं प्लीज बोल।
बल्कि सारे क्वेश्चन का जवाब आप बाद में दे दें, पहले अपने आर्गुमेंट्स।
My lord, as far as provisions other than Section 5 are concerned, with regards to practice and procedure, I have submitted that the competence is drawn from Article 191, read with entry 58, and of course together read with 142A. 191 in itself acknowledges, recognizes Parliament's power to make laws with respect to practice and procedure, and the term law used in 191 does not in any manner exclude an act of Parliament.
ये जो आप अगर एंट्री 58 को देखें, इसमें एंट्री 58 में आप किस उसमें आ रहे हैं? विदिन द लेजिस्लेटिव कॉम्पिटेंस ऑफ मजलिस शूरा,
yes,
or relates to the federation?
First part.
Okay, and so your reliance on item 58 is directly dependent upon or flowing from your argument that 191 confers legislative competence.
Yes.
Okay, point taken.
So this is the conclusion or some of what I have submitted on as far as legislative competence with respect to matters related to practice and procedure are concerned. Now, and then comes Section 5, which is a substantive right of appeal, which has been conferred, and which obviously, at least in my my submission is that for that we have to go to entry 55, and entry 55, my lord, does two things. It empowers the Parliament to legislate with respect to jurisdiction and powers of all courts with respect to all the matters in the list, and to such extent as is expressly provided by or under the Constitution. But as far as Supreme Court is concerned, it empowers the Parliament to only enlarge its jurisdiction and confer supplemental powers on it. So it does deal with Supreme Court's jurisdiction and powers, but only to enhance them, not to curtail them. But as far as other courts are concerned, both things can happen, subject to what is provided by or under the Constitution, the language of the Constitution.
So once that jurisdiction has been enlarged, that act cannot be repealed.
My lord, I was thinking about the question that you
taken away.
You mean to say that enlargement of jurisdiction includes right of appeal?
Yes, yes, sir. Because this is the appellate jurisdiction of the Supreme Court, which exists in the Constitution, the appellate jurisdiction. It is that jurisdiction.
In fact, the original jurisdiction has been enhanced. No? Under Article 184(3) is the original jurisdiction.
Original jurisdiction.
It has been enhanced by enlargement.
So my submission and my response to your question, my lord, is that nothing in Article 184 or 185 provide any extent to which they can be enlarged, because they do not so there is no bar on the Parliament to the extent to which the jurisdiction can be enlarged.
Is there any limit of enlargement, because the right of appeal has been given with retrospective effect? There is no cut-off date and it is open-ended. This question was also asked by me to Mr. Salahuddin, where it was not responded.
Mr. Attorney General, you have not given the details of express authorization that requires your...
My lords may note Article 212, Clause 1, subclauses A, B, C, and then read with Clause 2 of Article 212 with respect to administrative courts.